Okay.
All right, so we have a lot of people on the screen today, so I'm going to ask for people to identify themselves. So I have a pretty good sense of who the attorneys are. Who's the court reporter?
I'm a court reporter for Tom Giannotti.
All right. Ms. Noyes, you're a court reporter for Attorney Edwards. All right, so if you all need anything at any point, if something is unintelligible, or if you need someone to speak up, don't hesitate to indicate that. I want a clean record. So, and I'm not, I'm not shy about making sure I say speak up, or speak it directly into the microphone, or you're glitching. Now, ladies and gentlemen, I'm gonna look kind of weird because my progressives, the sweet spot is down here somewhere. And so if I'm doing this or looking crazy, it's not about your argument. It is about the fact that I hate these glasses. All right, let me start. We are recording, we are live streaming. For those of you who are not necessarily parties to this case, or you're here because somebody else is here, or you want to just see it, I'd rather you watch it on the YouTube channel. So we are live streaming on YouTube. You can just go on and search for courtroom 304 Clayton County and look for what is live streaming, and do it that way, because what I don't need is people speaking up out of turn, people interjecting or unmuting their microphone and interrupting the arguments that are being made. I also want to thank Ms. Hemmings for making Mr. Jelks's appearance possible, and for working with us to get that done. All right, so let's get started. We have a lot to do today. All right, so this is the plaintiff's case 2024 CV 03259. And as I've stated, I'm Judge Tammy Long Hayward. That's Tammy with an I, State Court of Clayton County. This is the plaintiff's Eden Tiketsky. And I may have not pronounced that properly, but please let me know and I'll correct it. And Asmaran Tiketsky, individually and as parents and natural guardians of Eliana Berhe, a minor. And the defendant, Walmart Stores East LP 125 Fayetteville LLC, Master Security Company LLC, and Adrian Lamar Jelks. So we have a couple of motions before the court. Of a motion to compel discovery between the plaintiff and Walmart. We have a motion to dismiss and a response in opposition between Mr. Jelks and the plaintiff, a motion for default judgment and response in opposition between Mr. Jelks and the plaintiff, and a motion to strike plaintiff's response and a response in opposition between Mr. Jelks and the plaintiff. All right, so let's go ahead and start with Mr. Jelks's arguments. So Mr. Jelks, you brought a motion to dismiss in this case. Please tell me, sir, what your motion is based on. It's my understanding that at this time you are pro se and not represented by counsel. Is that correct?
Yes, ma'am.
All right, raise your right hand for me.
Repeat your question, ma'am.
Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Okay, so for the purposes of this hearing, I really don't have a sense of, I am assuming that the criminal matters in this case have been concluded, but I do wish to let you know that anything that you say on the record can be used for this case or any case, even a criminal case that could be prosecuted against you. And so I just give you that warning because it is your right to know that. But at this point, sir, if you wish to proceed with telling me why you think this case should be dismissed, you may go ahead.
Well, man, see, man, they ain't let me bring my paperwork up here, so I can't really explain to you about everything.
Okay, what do you think the basis is of why you shouldn't be involved in this case?
Because Walmart's at fault, ma'am.
Okay, and why is Walmart at fault and not you?
Because I let them know what happened, and they ain't take action, ma'am.
Okay, And is it possible for both of you to be at fault, or you're saying only Walmart is at fault?
Only Walmart. If they would take action, none of this would have happened, man.
All right. All right. So that's the basis of Mr. Jelks's motion to dismiss. Did plaintiff want to respond?
Yes, Your Honor. My name is Jeb Butler on behalf of the plaintiffs. But our plan, if it suits the court today, is for me to handle Mr. Jelks's motion, and my co-counsel Tom Giannotti will handle the motion to compel.
That's fine.
I'll be short as Mr. Jelks was, but I did prepare a short visual presentation I'd like to share with Your Honor. It looks like that should be coming through.
It does show that you're sharing.
Great, thank you. I'll do facts very briefly. If we take the facts chronologically, the first thing that happens is that Walmart does start to learn in the years preceding this shooting that there is a lot of gang activity and crime in the area and at this store specifically. And then in the weeks or days preceding the shooting, we know from some text messages that Walmart starts to know that Mr. Jelks has some sort of HR related problems. It's not clear from the text exactly what those are. We haven't gotten to depositions yet, so I don't have a lot more facts about that. But the first thing chronologically is that Walmart knows it has a problem both with crime at this store generally and with Jelks specifically. On March 29, 2024, this shooting occurs. It starts when Adrian Jelks and another Walmart employee, Sandra Romero, walk to the front of the store, and they wait there for some period of time until a former Walmart employee, Antavius Holton, starts coming through the door. At that point, Mr. Jelks pulled out a pistol. It was a Glock 9mm, modified to fire automatically, which is to say, as long as Mr. Jelks held on the trigger, the pistol would continue to fire, and it held at least 19 rounds. We know that because 19 shell casings were recovered. He shoots 19 times, generally at former employee Antavius Holton, kills Holton, and then a stray bullet strikes Eliana Berry, who's 9 years old and is at Walmart with her father. Her injuries are serious, although thankfully not fatal. The bullet enters her left cheek and her face and lodges in her skull, not far below her brain, as you can see from that image in the top right on the screen. That white dot in her skull is the bullet. She has surgery. Doctors are unable to remove the bullet because it's too dangerous. It's too close to her brain or brain stem. So the bullet remains there today. That's serious because she has some elevated lead levels in her blood. And then psychological trauma is also a part of damages, of course. We have pretty good security footage of this shooting. It comes from a bunch of different angles. So what we've done is to go through the different angles and then compile it into one video clip to show the court. It'll last a little less than a minute. And with the court permission, I'll show that video now.
Any objection? Okay.
I'll hit play. Here we can see sort of generally where we are on the store. This is the entranceway. Behind us is the door that opens onto the parking lot. We're now facing that way. That the man there is Mr. Jelks. With the woman with the red hair is his coworker, Sandra Romero. Now we see a man walking toward the door in red pants. That is Antavius Holton, the former employee. So that was the shooting, and then here is the aftermath from our client's perspective. This is Eliana Berry being held by her father. As you can see, she's losing blood. I'll move now, unless the court wants me to do anything else, to the merits of the motion, and I promise to be brief, and I'm going to do it. I think we heard this. Mr. Jelks blames Walmart, and he has a right to do that, but it is not a ground for dismissal. In order to survive a motion to dismiss, a complaint need only give fair notice of the claim. This complaint meets that standard. The complaint says that Jelks fired a bunch of shots in the direction of customers, that Eliana was shot, and that he is liable for assault and battery. That states a claim. Additionally, by attaching an affidavit, Mr. Jelks converted his motion to dismiss into a motion for summary judgment, which should be denied as untimely because discovery is not complete. Mr. Jelks argues that our plaintiff's response was late. That is sort of superficially true. That's because we weren't served with the motion when Mr. Jelks filed his motion to dismiss. He didn't serve us with a copy of it, so we didn't have it and didn't know it had been filed at first. Mr. Jelks did include a certificate of service with his motion, which creates the rebuttable presumption that service was effectuated. But in fact, it was not effectuated. We did not get it and have submitted an affidavit to that effect, which which rebuts the presumption of service. So then we filed a response and timely opposed the motion. I'd say further that the remedy Mr. Jelks requests is default, and that would not be the appropriate remedy, even if plaintiffs had not timely responded to the motion to dismiss. The last thing I'll cover is Mr. Jelks' motion to strike. He asked to strike our pleadings. That would not be appropriate unless the standard of 911-12F were met. That standard is not met because the response to his motion is not redundant, immaterial, impertinent, or scandalous. So we believe the court should deny the motion to dismiss, deny the motion for default, and deny the motion to strike filed by Mr. Jelks. And unless the court has questions, that concludes my presentation.
All right. Mr. Jelks, did you have any response to the presentation made by Mr. Butler?
I can't see anything on the screen, man.
Okay.
I'm trying.
Did you hear what he stated with respect to the motion to dismiss?
Yes, ma'am.
Okay.
Yes, ma'am, I heard, but I couldn't really see what he was putting up there. And I'm trying to get one of these officers' attention so they can remove whatever's on the screen.
Are you looking at the video screen?
Yes, ma'am, but like I can't see nothing. Like
Can you see me?
no, ma'am. It's something above. It's something above it. Like it's another app.
Okay. So something sitting on top of what you should be looking at.
Yes, ma'am.
Okay. So Mr. Butler has argued that one, their response to the motion was timely because when you filed your motion, you didn't serve them. I'm sorry.
Repeat what you said, ma'am.
That when you filed your motions, you did not send a copy to their offices.
Sure, I can get that. Sure.
Good.
Mhm.
You understand what I'm saying?
Yes, ma'am. I just had to ask one of the ladies to remove this screen off so I can see everybody.
Okay.
But I'm pretty sure I did, ma'am.
Okay. How did you send it?
I'm pretty sure I had one of my family members sent a copy to them. Probably through, I think it was email, because I'm pretty sure I seen it in my paperwork when I had got it.
Okay, so you didn't do it personally. You relied upon somebody who's outside the correctional system to send it.
Yes, ma'am.
Okay. All right. The next thing is you're saying that the reason you should be dismissed is you let Walmart know what was going on, but they took no action. So
Yes,
you shouldn't be held responsible.
like I said, ma'am, if Walmart would have took action, none of this would have happened now.
All right. And for and you're asking for a default judgment. Do you know the basis of your default judgment request?
No, ma'am. Can you explain that to me?
Well, sir, you filed it.
Um,
Okay, I'll rely on your paperwork.
yes, ma'am.
Okay. All right. Anything else with respect to the motions and pleadings that Mr. Jelks has filed?
In case it clarifies anything, Mr. Jelks did serve some of his motions, but not the initial motion to dismiss.
So y'all
And
did
that's all.
receive some of them, just not that one.
That's correct, Your Honor.
Okay. All right. Next is the motion between the parties for the motion to compel between the plaintiffs and Walmart. So Mr. Jelks, I'll make a decision and issue a written order, which we will send you a copy of for all of the motions, including your 3 motions that you filed before the court, okay?
Yes, ma'am.
All right, so now I'm considering the motion to compel, which is a discovery issue between the plaintiffs and Walmart. All right, who's going to speak on behalf of the motion to compel?
Good afternoon, Your Honor. I'll be presenting on behalf of the plaintiffs. My name is Tom Giannotti.
Okay.
So I also have a visual presentation prepared.
Okay.
Go.
All right.
And with that, I'd first like to, Mr. Butler covered the facts, but I'd like to just touch briefly on our claims, and it has to do with the relevance of some of these discovery requests. And then I'll address the specific discovery requests that remain outstanding. And finally, I'll discuss the numerosity objections raised by Walmart. Of course, if the court would like to proceed in a different order, we're happy to oblige, if the court pleases.
I'm good with what you have.
All right. So Mr. Butler covered the facts pretty well. I would also just further note that Walmart's discovery responses have been, after several extensions were due in September of last year. And as to the first set of discovery, there was a second set of discovery that was due in December. It's obviously been several months since then, almost a year from the first time that Walmart responded to discovery, and there remain a number of issues outstanding. As to our claims, as Mr. Butler noted, Walmart had reported increase in gang activity and violent crimes. That's relevant to our negligent security case or negligent security claim, premises liability claim. And then we also have brought a claim for negligent hiring, training, supervision, and retention as to Jelks and Sandra Romero. We'll come back to this text message, but this is the text message that Mr. Butler referred to, that we believe that we're entitled to further discovery on that issue as well. And last, we also have a claim for vicarious liability. That's less of an issue, frankly, with regard to these discovery requests, but just want to note that as well. All right. So before addressing the specific discovery requests, I'd like to briefly talk about what we've called finality. By finality, we mean knowing whether Walmart has produced all responsive evidence and information. This is an issue common to many of Walmart's discovery responses, which were coupled with various objections, often boilerplate objections that didn't specify how exactly the request was deemed to be objectionable. Then Walmart went on to respond subject to those objections, again, without specifying whether it was withholding evidence pursuant to any number of those objections. And courts have disapproved of this practice, including the Georgia Supreme Court in the Conley case quoted on the screen here, as well as the Federal District Court in the Williams case, which was Judge Story's opinion, and pretty much hit the nail on the head right here with the text in bold, that we, as the plaintiffs, are left to wonder if the response is complete or only partially complete, with otherwise responsive information having been withheld pursuant to any number of objections. We'll see examples of this as we get into the specific requests, but just to give a few quick examples, Walmart wrote in its brief opposing our motion to compel that it has produced or identified as privileged all materials identified to date, other than the outstanding email communications, and then went on to say that it will supplement at some unspecified point in the future.
Okay, so let me ask this. So what is the privilege? Are they alleging that these are communications between them and counsel? Are they alleging that there's some kind of trademark or protected property right to their discovery responses? What is the privilege that they're asserting?
Well, from facially, it basically all of the above, Your Honor. I'll let Walmart speak to the more specifics of that, but they've asserted blanket objections about attorney-client privilege, work product protection, quote, other privilege that is not specified, as well as trade secrets, confidentiality, privacy. I think
So they threw the whole kit and caboodle at you.
I mean, that's the way we see it. But we'll get into more specifics. But that's exactly, you hit the nail on the head, Your Honor. That we can't tell. Neither us nor the court can tell whether these objections are valid without more information. And we fought for several months to get Walmart to produce an adequate privilege log, which eventually they did. But even that is delayed, and there's still things that are that there's a lot of unanswered questions. I'll put it that way. So just to give really quick examples, aside from the email communications, there is a monthly security tours that were referenced in one of the Walmart policies. We'll see. None of these documents were produced. They clearly exist. Walmart produced some annual security surveys, but no monthly surveys. So we know there's at least some documents already that Walmart possesses, but has not produced pursuant to any number of objections. And then also there's a third-party security expectations, which are what they call post orders for their third-party security guard. These were actually part of a contract between Master Security and Walmart. We recently got them from Master Security, who was recently added as an additional defendant in their discovery responses. But Walmart hadn't produced this. So again, another example is that we know that Walmart has other documents they just haven't produced, and that's what we're trying to. That's why we're here today. All right, so the first specific request, this really is 3 requests. The first 2 are very similar. That's RPDs 24 and 25. They essentially sought internal documents that would be evidence of prior misconduct by Mr. Jelks during his employment at Walmart. As the court can, as shown on the screen here, it's the same exact wording except for the latter. Basically, RPD 25 is broader than RPD 24, but they're both relevant to the same issues: notice, knowledge, and foreseeability on the part of Walmart. And that's central to our claims for negligent security and negligent supervision, hiring, retention, et cetera. Particularly with respect to the claim for negligent hiring, supervision, and retention, RPD 24 sought relevant evidence about Walmart's failure to address prior instances of misconduct by Jelks, including disputes between him and others at the Walmart store. You can see Walmart had again listed an entire laundry list of objections that appear boilerplate, and
I'm sorry, unduly invades the privacy of an employee. What privacy and expectation do employees have with respect to anything other than their social security number if it's records kept in the course of business?
That's exactly our position, Your Honor. And Walmart had redacted social security numbers per our agreement, and we have a confidentiality protective order in place as well. So we think that objection, you'll see that objection recurring frequently, but we think that objection should be overruled for that exact reason.
And the text message that you put up a few slides ago which appears to be between some unknown person and Mr. Jelks, indicating that there was a possibility that he would lose his job because of some issue going on between him and another person. That would indicate that there's something responsive to RPD 24 and 25.
Yes, ma'am, exactly. And actually, I think I have that one of the next slides. Yep, it's right here. So as Your Honor just noted, this is clearly relevant. Walmart's liability arises in part due to its failure to address these issues, these employee disputes and misconduct. And Walmart was considering firing him. It appears from this text message that that text message, the other party actually is Mr. Jelk's supervisor, one of his supervisors, named Mario Carradine. And Mr. Carradine in the text message here appears to be covering for Jelk, saying, I'm not going to let you lose your job. And in any event, nothing appears in Mr. Jelk's personnel file at Walmart, as one would expect to see if there was he's being disciplined via text message, essentially, but it wasn't reported through the proper channels, or at least if it was, it hasn't been produced. But obviously, this is relevant directly to our claims, and the objection that it's not relevant or not reasonably calculated should be overruled. Just to point out further, we did limit this. It's not facially limited by date, but it's inherently limited because Jelks worked at Walmart between September 14th of 2023 and the date of the shoot, or he was fired the day after the shooting. So we're working with a roughly 6.5 month period of time. And of course, we also limited the scope to, in this instance, Jelk's inappropriate conduct. And you'll see in RPD 24 is a little broader scope, but again, still reasonably tailored. This, again, we suspect there's other documents related to this dispute. And before we take depositions, we believe we're entitled to discover those documents as well as any others that are responsive to this request. Or if there aren't such documents, then we need to know that as well. But the problem, again, is what we call finality. Walmart's been saying for almost 12 months that it's going to produce emails once it finishes searching. From our count, just 2 emails have been produced. There's a few other in Walmart's privilege log that all apparently deal with investigative type of discussions between Walmart and its legal counsel. But again, that took 6 months to get the privilege log. But again, there's no indication as to when this search will ever be completed. And
is there any indication of spoliation?
That's a good question, Your Honor. I don't know, actually. But if that's the issue, is we don't know whether responsive documents exist and are being withheld, whether Walmart has even searched for those documents yet, or when Walmart, if ever, will produce them. And so this is where Walmart had said, well, back in January, that we'll continue to supplement at some unspecified point in the future, but we've given you everything we have so far, but we're not done searching. I mean, it's completely improper. So again, we covered the privilege log, and these are just some of the other documents that Walmart formally listed as what it was producing as responsive to this request, again, subject to any number of 10 objections. Moving on to request number 25. This request sought the same types of documents as the previous one, but it was slightly broader again in that it covered any interaction between Jelks and another Walmart employee, customer, or third party. Walmart lodged nearly identical objections to this request as well, so I won't belabor these points again, other than just to address Walmart's contention that, quote, any interaction would cover essentially an unlimited universe of documents. 2 points here. First, Jelks worked as a stalker at the Fayetteville Walmart store for, again, about 6.5 months. So there's inherent a limitation as to that period of time at one store. And second, the phrase any interaction is necessary to capture things that don't necessarily rise to the level of what Walmart, in determining which documents are responsive, would consider inappropriate. Uh, so, for example, Jelks has alleged that he experienced threats and harassment in the workplace during his employment with Walmart, as we heard a moment ago. That would be covered under RPD 25, but not necessarily 24 if if Walmart didn't consider that inappropriate conduct by Jelks. And as to the first point, frankly, it's a far stretch to suggest, as Walmart does in its brief, that this request calls for producing things like receipts for purchases of anything that Jelks stocked on the shelf at Walmart. If Jelks stocked a basketball on the shelves, then we would get all the receipts for basketballs responsive to this request. That's I think a very far stretch. And likewise, Walmart said it somehow seeks his benefit plan materials. I don't think that's a valid objection to this, but it's a balance really between trying to narrowly tailored and being too narrow and not capturing what is otherwise relevant. So we think this is a reasonably tailored request. To Walmart's objection, really quick, proportionality, that's in federal rules. That doesn't appear in the Georgia rules, as the court is aware. Just more boilerplate objections.
Essentially, they threw every privilege, every objection, every at you that covers the state and federal law.
Yep. And we don't know which ones are actually or what they're withholding pursuant to what objections, and that's required under both the Georgia and federal rules. But again, Walmart has clearly not performed the search that it's required to perform of all matters within its possession, custody, control under the discovery rules. Because 4 months later, Walmart got around to producing text messages, as we just saw, subject to its objections. But this is what I call a rolling document production. And this sort of rolling production is a problem because, as we've already seen, Walmart is going to string out its production indefinitely. And so in order...
Doesn't mean they haven't searched for it. It means they haven't produced it. That's the evidence before the court. I don't know whether they've searched for it or not. They may have everything responsive to every discovery request that you've made because they did the search. And that would be the smart move. If I were representing Walmart, I would find out everything and then object to it as it comes up or do the rolling production. But I wouldn't be sitting on your request for production without actually knowing whether it exists or not exists. And so I wouldn't presume that Walmart is dumb in the way that they operate, because no lawyer worth their salt is going to not do the search.
And Your Honor is probably correct in that, and perhaps I'm being slightly naive, but that's what Walmart said they were doing. They said, once we finish searching, we'll do it. That's kind of hard to believe that Walmart would sit on this for a year, but yeah, that's what they've written, and we've gotten no updates on this. So, in order for us to be able to take depositions, litigation, and move to the next stage, there has to be some deadline by which Walmart will have produced all responsive, discoverable, non-privileged documents and information. The third request here, number 33, this saw internal documents relating to the shooting, things like emails, text messages between Walmart employees discussing the shooting, what happened, who was involved, etc. Those would clearly be relevant and not privileged. It's, something like this is pretty shocking to see, and I'm sure that there were employees at Walmart that were talking about this, and they were probably told not to talk about it, but if there are text messages or emails that Walmart has within its possession, custody, or control, then those are discoverable and they're not privileged unless they were involving Walmart's, legal counsel or insurers. So, to the extent that Walmart claims that this calls for some privileged or work product documents, that we need to be able to assess the validity of that privilege. And Walmart's privilege log, even though it was produced 6 months later, does not appear to have any responsive emails other than, again, investigative emails with legal counsel. And we don't know, again, whether Walmart will get around to finding additional emails, or they already have them, or what. But we need to know if Walmart is withholding other documents pursuant to these objections. All right. I just covered that. Let's go on to RPDs 23 and then second RPD number 2. These both sought evidence of prior similar incidents, which are routinely admissible to show notice, knowledge, and foreseeability in both negligent security cases and in negligent hiring, retention, supervision cases. So I'm going to start with second RPD number 2 because there's a lot of overlap here. And frankly, RPD 2 is better. So we as the litigation moved on, we were able to refine and more accurately target things as we learn a little bit more information. So
so my question with these two was going to be, are you talking about actual legal cases within the jurisdiction of the store that were either like an arrest or a complaint was made with a law enforcement authority? Or are you talking about incidents that may be between the parties in the store, documented by someone in the store, that may be analogous to what would be in a criminal case?
I would say both, Your Honor, but as to the things that were actually incidents that were actually documented with law enforcement, that's a much more concrete example, and that is we actually we'll look at a couple examples of this, but we're seeking that as well as internal reports. For example, if an employee was disciplined internally for what may have happened between Mr. Jelks and this other person, if a report was made internally to Walmart, we would seek that as well. Does that answer Your Honor's question?
Yeah, because I was reading these, and the first one seems more targeted to any criminal matters that may have been documented by a law enforcement professional not associated with Walmart per se. The second one seems to be broader in that it covers any incidents that may be analogous to a criminal charge, but documented by Walmart.
Yes, that's right, Your Honor. It's really both. And so as to the second RPD number 2, again, it's broader and then it covers a 3-year period as opposed to the September 29th to March 29th period, roughly a year and a half. But we've worked to, again, refine this to more clearly define the subject matter, and we define violent act to include striking someone, attempting to strike someone, threatening someone with physical harm, discharging a firearm, or brandishing a weapon. Very clear, but yet Walmart still objected as vague, overbroad. I mean, the same boilerplate objections that we've seen over and over again. It's limited to the not just the Walmart store in Fayetteville, but any Walmart store in Georgia, and I'll get into why that's still relevant. One example would be the case. This was a personal injury case in a federal court involving the same defendant, Walmart Stores East, which operates Walmart stores in at least 20 states nationwide. And this was a negligence and product defect case that the court ordered Walmart to produce a list of all complaints within a 5-year period nationwide regarding the specifics of this claim, and noted that it would be subject to further discovery. And the court also ordered Walmart to produce any incident reports for those claims. We think Walmart should do the same here. The court should order Walmart.
But the distinction between the Ventura case and what's happening here is you only have one Mr. Jokes and one Mr. Horton. And unless they were employed at different stores and their behavior was replicated at different stores, then to ask for all of this from all of the stores I'm not sure of the relevance of that. I think it might be broaching upon something that could be considered too broad, because if you're talking about the personal interaction between these individuals that led to this particular incident, then all day, every day, I want to know all of the interactions with anybody who could have possibly had a conversation with Horton, a conversation with Jelks, a conversation with the people who supervise these individuals. But when we're moving it to other stores that are not involved in this, then I think it's harder to make that argument. Now, of course, I'm not agreeing with everything that they said to object to it, but I am thinking that overbroad might be appropriate unless you can show me a specific reason. And the difference is product, if there's a defective product, that can be in 1,000 stores. If there's a defective person, that's going to be in one store.
Yes, Your Honor. However, there's the broader relevance is to show essentially a pattern of other incidents involving other employees committing violent acts that Walmart would have been put on notice to know that it had a problem with not just Jelks, not just Holton, but a broader HR problem, essentially, that Walmart has a systemic failure to address employee disputes and misconduct. And we don't have full discovery on all of this yet, but Walmart does have, I think, what they call market managers, which essentially oversee multiple Walmarts in a particular region. So those people would be the same people to have been notified about problems with Jelks, Holton, other employees, and that could be at this Walmart store or others. And it's relevant to show how Walmart deals with these disputes or doesn't. So
okay, so are you limiting that to sort of regions, states, or nationwide?
We're not doing it nationwide, Your Honor. We limited it to the state of Georgia. We're not sure exactly what the market is. Walmart hasn't provided that information, but if we could potentially have additional discovery on that, we might be able to refine it more accurately to cover the same market that is covered by the same people that supervised the people that were supervising Jelks, essentially. But we don't know. That could be across the Southeast. It could be in Southeast, Southwest Atlanta, or we're just not sure. But this was essentially our attempt to reasonably tailor this for those reasons. So the Apple investment properties case that was cited in our briefing, this is one example of a court having ordered other incidents not involving the same claimant or the same employee as the perpetrator of the wrongdoing, essentially, that this was at a nursing home operator who had other residents that had similar issues, and the court said, oh, go ahead.
I think this makes my point. And from the standpoint of, so I've done like those large premises liability cases where we have to have a whole day, 2 days going through all of the criminal matters that may have pertained to this particular property or properties owned by this owner manager. And we have to go down every one of them. And we have to determine which of them are relevant, which would have put the owner operator on notice of the possibility of an event such as this occurring. So I'm familiar with establishing that, but this case here talks about one nursing home and incidents involving other parties. Well, if you're saying in this store, you want to know all of the incidents that happened between the employees and other employees and other customers, employees and suppliers, I'm all for that. But when we're talking about extending it beyond, I guess, this market, if we can ever determine what that is, then it gets into when we're talking about establishing a pattern or a system of operation, then it becomes more and more, nebulous about whether the same people are operating in the same way.
I understand that concern, Your Honor. One point on that is the Georgia Supreme Court's opinion in Taylor versus Devereaux Foundation. The court upheld a jury's award of punitive damages as well as the underlying compensatory damage. And in that case, the trial court had admitted this evidence of other similar incidents that involved This was a behavioral health facility operator, right? And one of the residents was sexually assaulted by one of the workers that was responsible for supervising the patients there. And so there were the same nursing home had other set facilities in other states. And
Okay.
the trial court had allowed the introduction of that evidence for the purpose of showing notice, knowledge, and intent on the part of the defendants. And it wasn't.
My caution, Mr. Giannotti, is not that that information is not relevant in some context, but what I want is to make the distinction between what is maybe a small company, a regional company, a company with just a few locations, as opposed to a worldwide juggernaut like Walmart, where if we're going to broaden this to, where does it stop? Does it stop at the national borders, the state borders, the international? Are we going international? So what I'm saying to you is, I'm fine with the request, but I want to make sure that it is narrowly tailored in scope, because when we start getting into, like, if we can define this market, I'm all for a clarification that defines the market. But beyond that, it starts to get a little bit more, it is, I can't justify it as much with respect to how many of these cases, how many of these Walmarts, how many of the regions or markets are we looking at to assess whether this information has an impact on this particular store. So I get, I'm following you up to this point. And now that we've clarified, you're looking for internal incidents, into things that were documented internally, also things that were documented by local law enforcement. But when we're talking about the scope of it all, I just want to make sure that it's narrow enough so that we're not out here just pulling in every case from all over the world.
Yes, Your Honor. I completely understand. And we think Georgia is a good place to draw the line there. Unless there are, and again, going back 3 years in the state of Georgia. We think that's a reasonable place to draw the line. However, if there's going to be additional discovery on what is included within this market, in other words, the people that supervised, looked after security at this store, who were also responsible for other stores within this market, if we can get discovery on that, then perhaps that could be further refined. But from what we know now, we think that Georgia statewide is a fair place to cut off that. We're not seeking nationwide or worldwide or anything like that. And Walmart, they've addressed this, and I think some of the briefing, or it may have just been between the correspondence between the lawyers, but Walmart had pointed out that this Taylor case was about punitive damages, and it's admissibility of evidence of punitive damages. It's not the case. This in Taylor, there was also a punitive damages award, and the court found that there were even subsequent incidents that were admissible to show, just for purposes of punitive damages, to show intent. But that wasn't strictly what this case was about, and we're not seeking subsequent reports. For example, there was a Walmart employee in Covington that in April of this year shot and killed another employee there. We're not seeking those reports, but we are seeking prior reports, and where we know that there have been prior instances of Walmart employees shooting people at Walmarts in other states, but we're not seeking those reports either. We're just seeking Georgia 3 years back.
All righty.
So I'll move on, or actually real quick before I do that, Your Honor, because this actually has to do with the other request, number 23 as well.
Okay.
Walmart, to the extent Walmart claims that this was vague, this is their own reporting policy. They said that these incident types should be called into the Emergency Operations Center, which, from what we understand, is a corporate level, nationwide type center that uses these exact terms to define what should be reported: inappropriate incident. But yet Walmart says that we're too vague, that they can't respond, and that's the term they use: violent incident, threat of violence. I mean, what's
the difference between these lists? So what I'm seeing is what looks to be analogous to like a legal determination. So we have a death, serious injury, hostage taking, kidnapping, extortion, potential explosive device, and then we have some kind of, I guess, company determination where it's inappropriate incident, kidnapping becomes a missing person, potential explosive devices, property damage. So what is the difference between these two lines, or are those separate events?
I'm sorry, Your Honor, I'm not sure if
So
I
I'm trying to determine if I'm only seeing part of it. So what I don't know what's on the edge of this that tells me what these incidents are. Are they dates? Are each of these columns separate incidents, or do these columns going across relate to each other?
Oh, I think, Your Honor, that as I understand this, is just a list of all events. I don't know if the columns
So
are.
this is like a what do they call it? When they're kind of giving you all the words that could possibly appear.
I believe this is a policy that Walmart says that
Okay.
distributes to its employees and says, if this happens at a Walmart store, it needs to be reported to Walmart corporate. So if the burglary happens, if an inappropriate
Okay.
incident happens, that I was just illustrating the point that, Walmart uses this terminology internally. So to the extent they're saying that they can't meaningfully respond to this because it's too vague, I mean, I don't know how else they would define it.
Okay, because I'm getting some of them are in black, some of them are in blue. I'm not sure what that designation is, and I didn't know whether this was a partial chart where there was some designation here on the left side that would have told me whether the chart is to be read going across or going down. So, and I told you these progressives aren't great.
I understand, Your Honor. I haven't cropped anything out that's meaningful. This was basically what was produced to us. And I don't know what the blue, black, I think maybe a hyperlink that we can.
Okay.
But yeah.
All righty.
In any event, one further point to emphasize here, it's relevant to both requests.
Hey, Tom,
Yes.
just to the extent the court wants to see the full document, I put it in the chat.
Oh, excellent.
Okay, thank you. So I'll look at that as soon as Mr. Giannotti is finished.
Thank you, Mr.
Thank
Butler.
you.
So this, we looked at this earlier in another slide, Your Honor, but this was another excerpt from a document that was produced. This was the annual security survey. We have one for 2023 that we looked at earlier. This was one from 2022. There's like 160 questions that they go through as a checklist, essentially. But one of these questions that's excerpted here was this gentleman named Ethan Meese, who is their market asset protection manager, went to the Fayetteville store and found gang activities been reported, and there's other stores within a 10-mile radius that have a lot of violent crime and gang activity too. And Walmart again can and does make decisions based on what is happening at these other Walmart stores. So again, it's relevant not just to the Fayetteville store, but other stores, at least within that market, as we've discussed.
Okay.
And just to use another example of sort of law enforcement reports, this was from a police report in a Union City Police Department had charged a Walmart employee for brandishing a firearm, who got in an argument with a customer, went out to the car and got his gun out, chambered around, and caused customers to scramble out of the way, almost like, fearing what happened here. So, I mean, something very similar is going on at a store that's less than 10 miles away in the same market. So that's just to further illustrate our point, Your Honor, of a pattern or systemic issues with HR problems.
Okay.
To the extent that Walmart is claiming work product or privilege, we've covered some of this already, but just to further emphasize that if it's prepared if an incident report is prepared in the regular course of business, as Your Honor is aware, that's not work product. And in any event, Walmart hasn't included any response to documents to this in their privilege log. And Your Honor is also familiar with the privacy objections and the admissibility objections. That's not the standard for admissibility. That's very familiar to everybody. as well as the privacy objection should be overruled, as we've already discussed. We can move on to request number 23. Same objections. This one, Walmart was a little more specific about what's vague, and that's why I had covered that slide earlier about
Yeah, they can't use what they use in their own corporate structure as something to be reported, and then say that it is vague as to what your request is. So yeah, that's all.
Absolutely. So again, this is a narrower request. What we saw with the second RPT.
Hold on just a second. I'm not sure who Marilyn is. I've asked you to attend through the live stream by watching it on YouTube. But if you don't stay muted, then I'm gonna get you off the screen. All right, go ahead, Mr. Giannotti.
Thank you, Your Honor. So this request was narrower. It's limited to the Fayetteville store only, and it seeks information about accusations of assault, battery, or inappropriate contact or language. That latter part is what Walmart primarily seems to take issue with. And one of the other issues that we've been dealing with in the context of this request and a couple others is where Walmart said, we will produce documents regarding, trying to get the exact wording here, but accusations of assault and battery against associates, which can have really two meanings. Just to be clear, we're not talking about just accusations where an associate is a victim of assault or battery, right? It's both ways, right? And further, Walmart is using the term associates as opposed to like employees or agents. We're not sure if there's a meaningful difference there. I believe Walmart calls all their employees.
They call them the associates.
But yeah, we just want to again be sure that there's not a distinction being made there. I don't believe there is, but let's see.
So just like Walmart calling employees associates is a term of art used by Walmart, if inappropriate conduct is a term of art used in your reporting rubric, then you can't say that that's vague, because whatever it means to you is what it should mean to Mr. Giannotti, and that's what you need to produce.
Actually, it's exactly right, Your Honor. So I think we've really covered most of these points already, so I won't belabor this too much. There was one other instance I wanted to point out. This actually happened at the Fayetteville store in November of 2022, where there was an employee and then another employee who had recently been fired, got into an altercation, and one who I think was the former employee, but is not totally clear from this report, was arrested for battery and terroristic threats. This would clearly be responsive to request number 23. We got this from the Fayetteville Police Department, not Walmart. And so again, just further example of what Walmart is, it would clearly be responsive to this request. It's clearly relevant. There are responsive documents that exist and they haven't been produced. Moving on. This was request number 22. As you can see, it sought all documents, evidence, and complaints, suggestions, comments, feedback regarding the safety or security of the Walmart premises, which is defined in our request to be the Fayetteville store. Walmart, again, actually did not assert a vagueness or overbreadth objection, but all the other ones, the familiar ones we've seen. It's relevant. Again, notice, knowledge, and foreseeability are key issues in any negligent security case, as well as in a negligent hiring, supervision, retention case. But specifically with regard to negligent security cases, as the court is well aware, this is a normal, very common thing to request feedback or evidence, documents evidencing complaints about safety or security, because the relevant question is whether the totality of the circumstances establish reasonable foreseeability. And so again, we have the periodic annual review document, but we don't have monthly security tour documents, which Walmart's own policy again says must be completed every month. And similarly, there's a list of questions that are checklist, if you will, that Walmart goes through each month. And those have not been produced, nor would anyone looking at the formal response really know that they haven't been produced. Walmart didn't even actually produce the annual reports in direct response to this request. I think it was to a different request. All that Walmart's agreed to produce in response to this request was a redacted or two redacted spreadsheets of customer feedback, which Walmart found by running search terms, quote, security and quote, safety. And then that was confined further to a 1-year period prior to the shooting. We took issue with some of this in the briefing. There was some sort of fussing about search terms. And I just want to point out that safety and security, like those exact quotes, would not necessarily capture all responsive complaints. After all, people don't normally talk like that. You know, a customer might write in saying, I felt unsafe, period. But there was a Google review that actually about this store that said basically that, I believe. And so the customer writing, I felt unsafe, quote, safety doesn't capture that. I mean, so the search terms itself, I'm not asking the court to really get into the ESI at this particular juncture, but you know, just to point out that even that is too narrow, and 1 year is too narrow. Similarly, as the court may be familiar from other, you know, large negligent security cases, typically 3 years, 4 years is standard practice.
Yeah.
So we think 1 year is too narrow, as well as the search terms. And again, Walmart said that it would produce additional documents, but still has not. They said that this would be basically 2 lists of claims that were limited to accusations of assault and battery or battery against associates at the Fayetteville store for this limited period. We again think that's too short of a period, and we think that it's too narrow in its scope. Even if Walmart doesn't mean to limit it to the, you know, against associates part, like it's a little unclear if it's intended to say we're only going to limit it to situations where associates are the victim of these assault or battery. But it should include both you know, accusations against associates, right? As well as accusation against other persons that committed something against an associate, just to further clarify that. And then again, the lists, just producing a list of claims, that was kind of like what the Ventura court ordered Walmart to produce nationwide, right? Because we can't meaningfully go through everything nationwide. So we'll start with a list, and then we can have further discovery on that. And that's sort of the approach the court took in Ventura. But we think that here, it's narrow enough already that that's not necessary to start with a list and then go from there. Walmart should go ahead and produce incident reports, written communications that deal with feedback again, about safety or security at this store during the period that we specified.
Go back to the slide this is what you actually said, the actual.
Sorry, that is what you're asking, Your Honor. And I was actually going to address the time scope as well, because it doesn't facially include one. And in all candor, I should have included one, but we conferred with Walmart and couldn't agree on the proper time scope. Walmart said a year or year and a half. In further candor to the court, we initially thought that this store had opened in September of 2022, because that's when their lease, or like the paperwork that's filed publicly said. It was like there was a conveyance. I think we learned it was between 2 commercial landlords, though. So the Walmart had actually been open prior to that. So we're at this time, Your Honor, we're asking for a 4-year period, which we think is standard across any negligent security case. And again, we've covered privilege already, but just to further point out, there's nothing in Walmart's privilege log that appears responsive to this. So if Walmart is going to claim privilege of work product, they haven't met that burden, and it's been so long that should be deemed waived. All right, and then Your Honor, these last 2 requests, or I think maybe the second to last, that say these are both basically about Walmart personnel. The first is specifically personnel file for Sandra Rebecca Romero Nunez, which I'll call.
Did they produce one for Cordero? What is it, Carradine Cordero, the gentleman who was supervising?
Yes, Your Honor. They did produce a the same documents as they produced for Romero, actually, the redacted paper personnel file, and then some spreadsheets that included disciplinary actions and exit interview. And we haven't brought up Carradine or other people because Walmart did appear to provide what we asked for in those instances. So
Okay.
we're not sure about that. We've
No,
tried
no,
to
I asked because to me, if I'm asking about her, I'm asking about Carradine. If they produce Carradine, then presumably what exists for Carradine exists for her, and it may be more. Okay,
Exactly.
so I'm trying to get a baseline.
Exactly, Your Honor. And they
right.
did produce this for Carradine and other supervisors of JELCS and did identify where they were not able to find, for example, an exit interview because they still worked at the store, right?
Okay, it was Romero Nunez. Was she an associate, or did she have some kind of supervisory responsibility?
She actually had the same exact job as Mr. JELCS.
Okay.
She was a stalker. But so the reason why we care about her and why I'm talking about her particularly and not the other employees is because Walmart's response was, for lack of a better term, like kind of squirrely. So
well, she seems to be involved. So she's walking him out. She's outside when it happens. She doesn't get shot. She's, like right there behind him in the frame. And so I would ask about her too. And I would expect if Walmart is going to produce for Carradine for an associate, I want to see the same stuff for her.
That's right, Your Honor. And to Walmart's, to some, give them credit, I guess they did produce some documents for Romero, but we have some issues with it, and it's more about finality in this instance. So just briefly, there's more than just, she was there, as Your Honor has just correctly noted. She was there at the front of the store and with JELCS the whole time, but it goes deeper than that, really. Well, first of all, she had been disciplined previously for leaving her assigned area to be with another associate who we suspect may have been JELCS. Again, that goes to negligent supervision. She and him had the same exact role. They were hired actually around the same, or they worked together at the same time. There's a lot of overlap between the dates of their employment. And then right before the shooting, she had this interaction with this unknown male figure in front of the store, and you can kind of see behind the door here that they appear to be handing off something. And we suspect there may be.
He's standing right here in the below picture. I can see him through the window.
Yes, ma'am. And yeah, you can see exactly. And so she like pulls out her phone and then goes and approaches him, and they have a conversation. And there's like a handoff of some sort. We don't know what that was about, and we suspect there may have been some drug transaction, or we don't know, but we think it could have been related to what happened here. In any event, Ms. Romero was arrested and charged with murder and aggravated assault as JELCS accomplice.
Okay, let me ask a question. So at the time that this happened, do you have any indication that either of these individuals were finished with their, my understanding was that JELCS was still clocked in, still working as an associate? Were they on a break? Were they at lunch? Were either of them taking a dinner break? Was there any reason to believe that they were not still actively working their assigned positions, but just not at their post?
Short answer, yes, Your Honor. Walmart identified that both were clocked in. They never clocked out. They were both clocked in. They took a 15-minute break, and that's when the shooting happened. They were both supposedly on a 15-minute break, clocked in to work for Walmart at this time.
Have they produced anything that indicates whether they were in fact on a break?
Not in terms of a document per se. Walmart has responded via interrogatory, written interrogatory response, essentially just the lawyer typing the clock in, clock out data, which presumably comes from an internal source at Walmart. So really quick, Your Honor, just to give Your Honor a little more background about Ms. Romero and why this is so relevant. Not only was she arrested for this, she ended up pleading guilty to obstruction as part of a plea bargain in connection with this shooting. But it goes, again, deeper than that. First of all, she had been arrested for felony robbery in 2021. And this is just a copy of the filed plea bargain or plea agreement and sentence. She was actually, so the timeline is quite interesting here. She was arrested in 2021 and then went to go work for Walmart a year and a half later or so. She was hired in February 2023 and then ended up pleading guilty to this charge in May, then left voluntarily for, quote, better opportunities, which actually was to go serve out a 90 to 120-day sentence in jail at the probation detention center, then went back to work for Walmart, reapplied, was rehired in September 2023, around the same time that Jelks applied, while she was on felony probation, serving a 20-year sentence. So, there's a lot of questions, again, raised about what Walmart knew about Ms. Romero's criminal history and why they kept her and rehired her. This is an excerpt from the preliminary hearing in the criminal action related to this shooting. If there was any doubt that we're talking about the same Sandra Romero here, that's her own defense lawyer saying that she was on this probation. And then Walmart, after the shooting, suspended her with pay for several months and then says that they've at times said she's a former associate, but then her personnel file that was produced says she's, quote, on leave. So is she working for Walmart? Is she not? Like, what is going on here? And then it's because it says, according to the personnel file, that she's still on unpaid suspension, or at least as of the date that was produced. And then further muddying the waters, Your Honor, Walmart has written previously that they don't have a traditional personnel file. There are various records that may relate to associates, but then they're producing what they call a personnel file. So we don't know what is out there that may exist that hasn't been produced. It's just, again, finality is a big problem with Ms. Romero, and that's why we've singled this request out, and not the other employees, because there's a lot going on with her that Walmart has not been completely forthcoming about, in our view. If she's currently employed, we need to know that. If she's not, we need to know that too. If not, then where are those documents that evidence her termination or her resignation? It wasn't included in the production.
There's no have the same issues of with production for Jelks.
Yes, exactly, Your Honor. Same thing. There's no mention of any of the shooting or anything in her personnel file, which one would expect to see in terms of disciplinary action, et cetera. If they're privileged as far as something that Walmart's counsel did, then Walmart needs to tell us that and put it in the privilege law.
No, I mean, did you have these same issues with your request for production of personnel paperwork or personnel documentation for Jelks as you had with Romero Nunez?
No, Your Honor. As far as we can tell, the
reason I'm asking these questions is like Caradine, Jelks, Romero Nunez. I'm asking because sometimes it just doesn't exist. Sometimes the Walmart she worked at before, or whoever hired her before, doesn't know all of this when they hire her the second time. So what I'm asking is, I need a baseline for whether they're just not providing anything from a perspective of personnel issues, or whether it's just this particular person, if they don't have a traditional HR file where somebody goes to, now it's computer, you could go click on a name in a computer, and then everything that comes up under their name is documented in chronological order or whatever kind of order. But if they're saying that they don't have, and it's hard for me to believe that their HR doesn't work like any other HR, where they have to document things for associates. But if they're saying that they don't have that, is what they produced similar to what they produced for other individuals where you've requested their personnel file? Because I want to know what the anomalies are. If we can address those, it's fine. If this is similar to what's already been produced, then maybe there is no there.
Right, Your Honor. And that's actually that goes to the heart of our concern about finality. If they don't exist, then we should have a clear response to be able to know that. But when Walmart is saying we're responding subject to, 7 different objections, what are we to do? There's no way to assess whether it's complete. If they don't exist, then fine, but we should be able to tell that from looking at the response. And to answer Your Honor's question about how this compares with what's been produced to from other Walmart employees. It appears similar at first glance, but again, if you looking at the specific file for Romero, it says she's on leave, but there's like, well, how is she on leave and there's nothing else in the file about her role in the shooting or what was done after. And of course, it happened after the shooting, but this goes to a larger pattern. If Walmart is hiring convicted felons, violent felons, and then rehiring them again. And by the way, Your Honor, this was the same Walmart, Fayetteville store, not a different
I'm
Walmart.
sorry, I was just leaving open for the
Yeah.
possibility that it was more than one because I saw Pickens County was where she took the plea.
Yeah, she worked at the Walmart both times. She just happened to be up in Pickens County, I guess, for this event. But without, belaboring the point about just Romero, I mean,
Gotcha.
it is, we singled out Romero specifically because of the issues with what Walmart knew about her criminal past and what Walmart is saying about her status as an employee. Is she currently employed there or not? It's not clear whether she is or not, and Walmart hasn't said. They've said contradictory things, which they haven't done for other employees, who they clearly said, this is when this person either works here or they don't, right? With regard to Carradine, Jelks, and the other supervisors of Jelks that Walmart identified. So that's why we're not talking about the other employees, because those productions did appear to be complete, although now Your Honor has me questioning. But for purposes of this motion, we're not concerned about the other employees.
Okay.
Your Honor, this second to last one here, interrogatory 20, we asked to identify every Walmart employee who worked at this Fayetteville store for this roughly year and a half period prior, and further asked Walmart to state the job title, the dates of employment, which Walmart didn't do, and then the name, address, telephone number, particularly asked to former employees, because under the State Bar's formal advisory opinion cited in the briefing, we can permissibly contact those people within the rules of professional responsibility, whereas obviously we cannot contact current employees of Walmart. Walmart has said, well, we object to contacting anyone, any employee or agent of Walmart. Well, that's just not the law. But in any event, Walmart takes issue with this request as overly broad and let's see, where are the objections here? Here we go. Vague, overly broad, not reasonably targeted, and not relevant, et cetera. And then again, the privacy concern, which we've covered. But Walmart's the gist of Walmart's objection here is that we're a huge company. Most of these people aren't involved. They don't have relevant information. We get that, but some of them do. We've already known that they do. And there's been already been instances of Walmart not identifying people who they later come and produce evidence that was otherwise discoverable. So this is what I'm getting at here. This actually goes to the next request. Here we go. So I'll come back to this, Your Honor, but there was an employee named Will Smith. So Will Smith, as we've learned, was we think at least is the Will referenced in that text message we saw earlier with Carradine and Jelks. This was the other person that Jelks had a dispute with. Walmart belatedly produced an affidavit from this Will Smith person who was a former employee at that time. The affidavit was from October of 2024. So Walmart's had this affidavit the whole time. They only recently produced it a few months ago, but Walmart never identified Will Smith as one of the people that worked at the Walmart, even though he did work at the Walmart during this time. And again, we would have no way of knowing that if Walmart hadn't happened to get an affidavit from him. And this is an issue of finality, that this request Walmart saying, well, subject to this, to all these objections, here's a list of employees that we are going to identify. They identified 10 associates who may have relevant information, and then a list of hourly associates who clocked in for that day and then clocked out at some time after, for the day of the shooting, I mean. They haven't provided dates of employment for those people, and so that's made narrowing this more difficult than it should be. But Will Smith, again, was one person that was not identified because he wasn't working on that day, but he still had relevant information, clearly, because Walmart even got an affidavit from him talking about his interactions with Jelks. So, I mean, it's just for Walmart to say, just conclusively say, well, most of these people don't have any relevant information, so we shouldn't have to provide any information, or essentially we can cherry pick the people that we think that we should tell you about. And that's essentially the issue with this request. Many of the people would not know Jugs or have even interacted with him. That's completely unsupported. They haven't provided affidavits or anything like that, and this is just a completely conclusory statement, and we don't think.
I was going to say that's pretty conclusory. We don't know what people know.
Exactly, Your Honor. So, Walmart has identified the most recent response was last November. Again, the issue with Sandra Romero and whether she's currently employed there or not. They identify as a former associate then, but then she's apparently been on leave this whole time, so we don't know. But these are the people that we've managed to identify, reading between the lines, essentially, with their dates of employment. And if we think that the request itself is fine as written, it's right there in bold, Your Honor. But if the court is concerned about the scope, another alternative could be to identify employees who worked at the Walmart store at the same time as Holton, Jelks, Romero, and Smith. But we do think that there's likely other people that would not be captured in that we just don't know about. So we're asking the court to order Walmart to fully respond to this interrogatory. Right. The last request, Your Honor, here is request number 17. This sought witness statements, and we specifically excluded attorney work product, but included statements taken during the ordinary course of business or by non-attorneys. And Walmart objected, of course, to work product and privilege and other unspecified privilege, and then vagueness and overbreadth. There's nothing vague or overbroad about witness statements. That's a common thing in any lawsuit. Of course, we understand that there may be some statements that are considered work product, but Walmart didn't include them in their privilege log. So if it might have been privileged initially, it's not, because Walmart's waived that. I mean, Walmart waited 3 months to provide a privilege log that even contained the level of detail that was necessary to evaluate this. And then 5 months, again, went by before they provided a more adequate privilege log. But that doesn't mention anything about any witness statements. So if there are any, like we know that did exist in October for Will Smith that Walmart didn't disclose, probably pursuant to claims privilege or work product. We don't know about them, So all that Walmart was willing to produce, subject to those objections, was Jelk's personnel file and his exit interview, or so to speak. And then a spreadsheet of their courtesy officers, or security officers' incident report for the shooting itself. Again, they didn't produce the affidavit that they had at the time for Will Smith, didn't log it in a privilege log, didn't provide a privilege log that even described the level of detail necessary until 5 months after the response was due. And as the court can see from the authority cited here as persuasive in the federal rules, that is an adequate grounds to find that the privilege or work product protection has been waived. That
go back to your actual request.
Yes, Your Honor.
All right. So produce witness statements obtained from any person relevant to this lawsuit. my question is, are you intending this to cover any witness statements that may pertain to any previous interaction between the parties that led that where the shooting subsequently occurred as a result of that? Because that can be read to say the lawsuit is about the shooting, so I'm only going to produce the statements that are relevant that we took on the date of the shooting. Now, this would presumably, unless a judge is willing to look at it in such a broad context, but this would presumably exclude any, well, Horton and Jukes got into it today in the deli section, and somebody witnessed it and they wrote a statement. So I'm asking because this request for production can be better defined. They may be responding to what you're asking, but not what you intend.
Understood, Your Honor. I can understand that. You know, we can further define it, but you know, really, this sought witness statements that were taken in response to the shooting, and typically it happens in any sort of incident. Now, in this instance, Walmart has said, well, we immediately hired outside counsel, and they took all the statements, but none of them appear in the privilege log. So we're not, I mean, we did exclude it. So I can understand that. But, you know, that's really what the intention was. But, you know, Walmart clearly did have a witness statement that obviously was relevant to this lawsuit, and did not produce it. So I can understand that concern, Your Honor, but I don't think it excuses Walmart's failure to produce at least that statement. And our question again is, well, what other statements does Walmart have that they haven't produced and haven't logged? But Your Honor, we're happy to try to work to refine that request, if that would please the court.
Okay.
And then I'm going to end, Your Honor, with Walmart's numerosity objections. So we served 42 interrogatories. The first set was numbered 1 through 39. The second set was numbered 1 and 2. Walmart went in their response, they counted the subparts and then basically added numbers and then renumbered everything. And so I went back and looked, and I'll pull a couple of them up here. But in all candor, the court, Your Honor, ROG 16 probably did have some subparts. But ROG 24, ROG 39, not. I disagree there. And we'll look at those. But in any event, Walmart refused to answer number 39 and beyond. And somewhat ironically, I suppose, number 39 asked Walmart whether any responsive documents had been withheld, lost, misplaced, etc. So that's kind of the crux of what we're here about today. It could have really simplified things, but Walmart decided that that interrogatory counted as a separate interrogatory for each and every request for production. So have any documents responsive to the RPDs been withheld, essentially? Say, well, that's actually, there's 40 RPDs, and so that's 40 additional requests, and that's just not how the law treats subparts. I'll come back to that in a moment, but just generally, as the court's aware, we get 50 interrogatories. A party gets 50 interrogatories. Here, we have at least 2 parties, and we've argued in the briefing as well that the fact that there's a minor and parents claims actually would expand it to 3 parties. So, but at the very least, we get 100. We've not served anywhere close to 100. I think even if you count the subparts in interrogatory 16, we've served 46, and that's because we were counting 39 and 24 as a single interrogatory. The court's familiar that it has discretion to resolve this dispute, and
y'all wouldn't be here otherwise.
We would ask the court to find that this we've served no more than 46 ROGs. And the reason, again, Your Honor, is because this is persuasive authority from the federal rules, which do include the phrase discrete as opposed to just subparts, but courts have treated it this way because for lack of other definition by Georgia courts, that when a subpart is asking about this, the same subject matter essentially as the initial, as the court is probably familiar, that's a single interrogatory. So asking if any documents have been withheld, that's not a separate interrogatory for every single document request. And that's actually from the advisory committee notes to the federal rule. Likewise, interrogatory 24, we asked to identify employees that hired Adrian Jelks, as well as documents provided to Walmart by Jelks, like his resume, his references, which there were none, his employment history, which he gave none, the existence of any notes in the interview process, and then what the background check process was like to make sure that Adrian Jelks was qualified when he applied for Walmart. That's all asking about the same subject, hiring Adrian Jelks. We don't think that that's appropriately considered discrete separate subjects, Your Honor. But even if it were, we would still be well within the numerosity limits provided by Rule 33. And last, Your Honor, if the court does not want to indulge in this counting exercise, that's also fine. We would ask for leave to serve 20 additional interrogatories based on showing complexity and undue hardship. This case involves multiple claims. There's different burdens of proof for each of those claims. There's a lot of Walmart corporate policies that interrelate to one another, a lot of different departments and employees at Walmart that communicate with one another. And again, as Your Honor is aware, we're seeking documents concerning incidents at other Walmart stores as well. So we think that that justifies a showing of complexity. And of course, if we were not able to obtain additional interrogatories, then we'd have to go through a bunch of depositions and more RPDs and probably end up back here again for a second time about the RPDs. And that's just going to be less efficient and more burdensome on everybody involved. And really, if Walmart did have to answer 20 more, even more interrogatories, that's not going to really prejudice Walmart. It's going to be a way more efficient way of resolving these questions. And we've done what we think we've a reasonably targeted, relevant interrogatories. We're not sending boilerplate interrogatories, by the hundreds to Walmart. We're not seeking that. We think this is a reasonable request. And again, we'd ask the court to overrule Walmart's numerosity objections. And in the alternative, grant us leave to serve more interrogatories. That's all I have, Your Honor.
All right, Mr. Butler. You can take your, yeah, there you go. Mr. Butler, okay, there you are.
We can't hear you.
We can't hear you, sir. It doesn't show that you're muted, but we have no volume.
All right. Is this better?
Yes.
You called me, Your Honor. I think you probably meant to call Walmart's counsel.
Oh, I'm sorry.
But I'll argue
right.
for them if they'll let me.
No, who's Walmart's counsel?
Hi, Judge. I'm Logan
Okay.
Owens on behalf of
Ms.
Walmart.
Owens. Didn't
Thank
mean to slight you. I just had seen Mr. Butler, and I'm trying to keep all my horses in a row.
That's no problem. I'm sure he would have liked to argue that. All right, Judge. I just want to start. I'm going to skip around probably a little bit based on what Mr. Giannotti discussed. And if I miss anything that you have a question about, I know you'll stop me. So I just want to start by saying, I want to emphasize one point to the court. Walmart has acted diligently and in good faith this whole time during the discovery process. And we produced a massive amount of video, documents, personnel files that we'll talk about, files, policies, and I'll show the court, if the court will allow me. I also put together a small PowerPoint.
She did.
And we've supplemented repeatedly, which is what I want to show the court. And so what plaintiffs are now seeking goes far beyond what the law requires us to do. We have tried to work with them. We've gone back and forth. Still happy to do that, Your Honor, on tailoring some of this stuff so we can give them what they're asking for, if it exists.
Well, that would be more believable, Ms. Owens, if I didn't get a lot of the responses being things that don't even apply to this case. And otherwise privileged, like if it's not on your privilege log, if the whole point was to do a privilege log to identify those things that would be outside the scope of discovery or protected in discovery, meaning the court could do an in-camera review and then allow redactions or things like that. But to have the opportunity to produce a privilege log and then to claim that everything not on the privilege log is still privileged, it just, okay, let me just say to all of you, I am not a fan of protracted discovery. I just had a case that resolved finally last year where discovery, we went back and forth for years, and it just drives me nuts. And every time I kind of pinned it down, they changed attorneys and we were back at all of that we're doing. So I'm not a fan of big corporations kind of like throwing everything at me when it comes to discovery. I'm going to be very, very pinpoint when it comes to this.
I understand that, Judge. And I'm
just not a fan of the let's throw everything at them and say this doesn't apply because this, and we're going to just list the whole kit and caboodle. And then we're going to have to work backwards to get. And now I'm not saying that y'all haven't produced a lot of stuff, because I'm sure, but let's just, I don't want to take 3 years to get down to the nitty gritty.
I understand, Judge. And I just ask that the court give us an opportunity to respond, because I'm not going to sit here and say that plaintiffs are, fabricating anything, but we have a very different perspective. And our perspective is that our objections are not boilerplate. They are specific to the responses, and specifically the privilege log issue. If there's any confusion about that, we have produced a privilege log. Now, they complain.
I just said that.
Okay. I didn't know if there was confusion there. They complain that there's certain things not on the privilege log. Well, that may be because, like you indicated earlier, Your Honor, maybe that item doesn't exist. Maybe the question wasn't asked. That is, maybe we don't have something that's responsive, but we have given them a privilege log that detailed certain email communications that we assert are work product, different things. And I think it's about 30 pages long, the privilege log. So we do have that, and happy to show that to the court if that's something that the court would like to look at. So if I can, Judge, I'm just going to pull up this screen share so that I can, let's see. Well, am I enabled to share on here, Judge?
Yes.
Okay. I press share screen, but this could be user error. All right, Judge, are you able to see that?
I do.
Okay, great. All right. So, Your Honor, I just want to talk a little bit about how we got here, and what's gone on to date, because I know there's a lot of talk about what Walmart has done and what we haven't done. And this is sort of the timeline leading up to plaintiff's motion. So June 12th of last year, complaint was filed. The plaintiffs served their first RPDs and interrogatories. July 3rd, they were contacted by the prior counsel for Walmart. And so just to let Your Honor know, we came in November, our firm, Carlton Fields. And so we came in dealing with some issues. And prior counsel contacted them. At that time, I think that's where the extensions, that Mr. Giannotti referred to started. Now, August 20th, defendant Walmart went ahead and produced a lot of the video footage from the store going around the specific incident. We continued to produce, I think, a terabyte of video footage after that time. September 8th, Walmart responds to plaintiffs' first request for production and interrogatories. On October 7th, not even a month later, there's the first supplement to both of those items. October 31st, plaintiffs file or serve their second interrogatories and second request for production. November 13th, Walmart responds to the second supplemental interrogatories and request for production. November 23rd is when Walmart's prior counsel withdrew from the case. Now, this was just a month before plaintiffs filed their motion to compel. So all of this has gone on up until this point. December 13th, Walmart responds to plaintiff's second request for production and interrogatories.
Okay.
Plaintiffs filed their motion to compel on December 20th, 2024. So again, less than a month after prior counsel withdrew, Walmart at that point, as you saw, had completed the initial responses to their requests and 2 different supplemental responses. And they went ahead and filed the motion with the court. So I just want the court to understand, since that time, what we've been doing. January 8th rolls around. We're responding to this motion to compel, and we're also serving our third supplemental responses to plaintiffs' first requests. And as you can see, and I won't, belabor at this point, but January 14th, we produced more responses. January 21st, more responses. So it's a rolling production, as you kind of indicated earlier, as it is in discovery. Things are, that's why parties are required to supplement as discovery goes on. And so that's what's going on here. March 21st, our 5th supplemental response. Then you see on May 2nd, plaintiffs file more discovery. May 16th, our 6th supplemental response. And then June, we also filed a 3rd supplemental response. So all of that to say, Your Honor, all of that to say is we've been operating in good faith. I don't think that it's fair to indicate, for anyone to indicate that we haven't. It's included 15 plus productions, ongoing rolling disclosures. The other issue, plaintiffs want to complain about the timing. Well, there's sensitive materials, videos, personnel files, and we can talk a little bit about that in the privacy issues. But, some of these employees that are irrelevant to this case, those are their personal sensitive information that's located in their personnel files. And we really wanted to get a protective order entered in the case. And what we did in those first few productions is say, hey, look, we'll give you all this. This is what we have, but we really need this protective order. And if you go back to some of the 6.4 letters and the arguments that we had back and forth and the discussions that we had, plaintiff didn't want to enter into a protective order. They just didn't.
So here's my question.
Yes, ma'am.
So, because you can always appeal to the court for a protective order, but what specifically? So most people, when they work for a company, they understand that certain things the company is supposed to keep safe, but there are times when certain things will be disclosed.
Yeah.
What in the personnel files or personnel documents what was the content of what would have been in a protective order? So why didn't we move forward with that? Because it seems that it would have addressed some of these issues.
Yes, ma'am. And we did end up finally coming to an agreement on the protective order 3 months in. So when they talk about delay, I just want the court to understand we presented them a draft protective order that Walmart uses regularly in litigation that they've been involved in. And we said, hey, look, we're open to suggestions, but we didn't come to an agreement on that until December. And so many of the items that were produced, they were pursuant to that protective order. So, disciplinary actions. And you talked about, and I think you mentioned Mr. Carradine. Again, I'm skipping around. But, one of the requests they took issue with in their motion to compel was the issue about the supervisor's personnel files. As Mr. Giannotti indicated, we've given him all of that. So we have given them 8 different people their personnel files, and there are, concerns from Walmart as an employer about disciplinary actions of people that are maybe relevant to the lawsuit, but they're not directly related. They're not a Mr. Jelks. They're not, a Miss Nunez. And it's important for us to get into place before we produce a lot of that stuff. So as I showed you in that timeline after January, we really started producing things, but plaintiffs should have known. We told them, hey, look, we're not giving you any of this until we enter a protective order. It didn't get entered until December 13th. They chose to go to the court 7 days later. I just don't, I think we could have worked something out between the parties.
Now we're October 1st. And so some of these things are still existing even after the agreement on a protective order, which, as you've stated, Walmart has done its due diligence in supplementing, and I get that, lots of supplements. And so with respect to what is still outstanding, there seems to have been an opportunity for ample time to at least supplement or to finalize certain of the objections that were made to the RPDs and the ROGs that we're here about.
I think so, and I understand.
Or produce them pursuant to the protective order.
Yes, ma'am. And I think where we're, at sort of an impasse is we have gone back to plaintiffs' counsel and said, words like security and safety, searching a corporation like this, their system, I'm just using that as an example. We really need these tailored. We really need an ESI protocol. And I know that Mr. Giannotti said, hey, we don't need to get into that. But really, given the scale and the complexity of the case and our data systems, it really is essential because, the company's database, it spans multiple platforms, custodians, data sources, repositories. I mean, you deal with these sort of things enough that you probably understand that. And without a tailored ESI protocol, some of these discovery efforts are inefficient. And as we've objected to, it's overly burdensome, specifically to, I'm thinking of one of the things that Mr. Giannotti brought up about the store-wide search on the associates and, complaints and accusations and that sort of thing. And he brought up the Taylor Devereaux case. We told them in a 6.4 letter, we said, look, we would ultimately have to manually search over 100,000 records and go through each employee's disciplinary file to find out this information you're looking for. And what the Taylor court talked about was what could be evaluated as evidence in trial. It wasn't a discovery standard. So, a lot of it, Your Honor, I think could be worked through with tailoring ESI protocol.
But Ms. Owens,
yes,
it's sort of like, you know more about what they don't know. And so if you're talking about the systems that exist to maintain your information, we're talking about multiple protocols, we're talking about multiple custodians, multiple operating systems. So when you say to them, well, you need to refine your search because this is not helping us. Well, they don't know how to refine their search if you're dealing with all of the different things. So a company like Walmart, would presume that there's a certain level of centralization, not necessarily down to the store in Fayetteville, the headquarters in, I guess, Arkansas has all of their personnel records, but at some point there's some repository of the personnel records of any incident statements, because I'm looking at this chart and it documents what incidents need to be reported. And it says, and let me work with my cheaters here, the following incident types should be called into the Emergency Operations Center, and it gives a phone number, or your local country/market data incident reporting channels. These resources are available 24 hours a day, 7 days a week. review the global policy for reporting data incidents for contact information and reporting channels, notify the EOC of the incident when it is safe to do so. Now, when you're talking about security and safety, but you got a whole protocol about what should be turned into the EOC for them to reference what you document as an inappropriate incident or a product tampering. So if they narrow it to what is just important to them with respect to interpersonal difficulties between associates and then a shooting. So you're giving them, like, your protocol tells people what to define things as or what to call a thing. And when they call it that thing, y'all said, no, that's too vague. And
Well,
so this would suggest a centralized repository of reported incidents that you all could easily go to and say, okay, on this date for this store, an incident was reported that aligns with this heading: car, truck, jacket, explosion, fight, hostage, kidnapping, extortion. But for you to then say, well, it's all over the place. It is a multi-billion-dollar corporation, but I don't get it's all over the place.
Well, it's all over the place, Your Honor, because any interaction, any inappropriate conduct are the kind of terms that they're using. For example,
not that they're using, no, that you all have designated in this document.
Well, that document, Your Honor, that's for our employees. So if you're an employee working,
I want to know what the employees know. What's your point?
So
they can't use what you've designated. So if you tell the employees, this is an incident that needs to be reported, this is what you call it, this is where you report it, this is how you document it. But now they're not able to rely on that because they got to use something for somebody who's not an employee.
I think the difference I'm trying to point out here is that EOC document that you're looking at, that's for reporting for employees, right? So they can, ma'am.
That's where you get the nitty gritty. The employees are going to tell me what's happening, such that it's maybe an incident that could be related to something. It is discoverable and could relate to something that could be used at trial. And so why can't he use this?
I think saying any inappropriate conduct in a request between, in a lawsuit, the results that's going to yield is not going to necessarily
yield when your associates call it in.
That EOC reporting line can be from anything from somebody inappropriately touched you in the store. I mean, that's not relevant to this case.
Well, well, then don't produce that part. Just say this is an inappropriate touch and this is not relevant. But if you're telling him it's too vague, but you're saying this is how it gets reported, how's he going to narrow his request if this is what you tell this is what at the source you tell the associates? If this happens, this is what you report and this is how you document it.
I think we're dealing with employees. We're dealing with lay people in that situation. And this is their hotline where they can call, they can complain about anything they want.
As a plaintiff's attorney, that would be what I want.
But they also are looking for things that should be specific to this case. And so my thought is,
as the judge, if you bring it to me and say, Judge, we produced this, but we're going to need to have all of these things redacted, as I've done with premises liability cases before, you bring me the whole kit, you bring me everything. And then we go through it line by line, incident by incident, and I tell y'all what I'm going to allow and what I'm not going to allow. But if y'all don't produce it, then we can't do that. And so you're saying I'm going to gatekeep from the beginning. Anything that an employee presented, they're not going to get because the employee said it. But maybe that's exactly what they want.
Well, I think that
I don't know the basis for your refusal to give this information.
The basis is their request is overbroad.
It's not.
It's vague.
It's not overbroad until I say it is.
So is it the court's position that we should, it could be, Your Honor, and like I was trying to explain to plaintiffs counsel, in our previous, discussions about let's try to limit it. The burden.
Okay, tell me what your limitations are on
it. We have to go through every single document, and it could be hundreds of thousands of documents if we're talking about inappropriate conduct in a request. And so if we,
but if that's how they, okay, so let's go back to, if we don't, inappropriate conduct, let's forget that one. But let's talk about, let's see what else. Threat of violence.
I'm sorry?
Threat of violence. So on here it says threat of violence, and this is the one that's in blue, so there's a hyperlink. Can you have those?
Your Honor, I don't have a copy. I mean, I have that copy that they put in the chat, but this is a policy, an internal policy. So let me pull that up.
Okay.
Okay, I'm looking at it.
Mm-hmm. So if I wanted to know for that store, threat, and please don't insult my intelligence by saying it's all paper and we'd have to look through the documents, because this is Walmart. Come on now. If anybody has digital files that could be searched or a program could be written to search the files, Walmart does. So let's talk about it. So you're saying inappropriate incident as reported by the associate on the ground is too vague, but threat of violence, let's talk about that one.
Okay. What's your question?
Is that too vague?
I think if it relates to, if we can narrow it so it's related to the case.
Threats of violence from this store.
From this store, and it is the scope limited. I mean, all of our objections are
3 years.
Scope.
3 years.
I still think it's too broad, because threat of violence has a cashier been threatened by, a customer. Is that relevant?
And that's what I'm telling you. Produce it, and then when we come for motions in limine or pretrial motions, then I make the decision. But it is discoverable and possibly could lead to something for use at trial. You can't say it's not if you haven't produced it and had that conversation with me by saying, I'm just not going to produce it because I'm going to decide that it is not discoverable or it's not something to lead to something discoverable that could be used at trial. You're making a determination that it really rests with me.
Your Honor, I am not making that determination. We simply objected to what we on the.
And if I limit the scope, if I say, get the scope right, Mr. Giannotti, I don't want to see anything over 3 years. I don't want to see anything subsequent to the incident because that doesn't concern me. I don't want to see anything from every store in Georgia. If we can figure out what this market is, if that's like a regional designation, then maybe that, but particularly this store, if I'm limiting it in that context, and y'all are still saying we're not going to produce it, where are we at that?
Well, Your Honor, I think if you're saying, hey, let's put some parameters on this, that would be helpful, because I think what we've tried to do is not make the decision, but say, hey, look, this is unduly burdensome, and these are all the reasons why, explaining, hey, we're going to have to go through 100,000 documents or whatever it was for whatever specific request. We have simply just said, these are the ones that we can't agree with. And as you saw, we continue to produce things that they've dropped off of their motion to compel. So there have been a few that they've dropped off because we have either gotten them what they were looking for. I still don't understand, just skipping to this really quickly, the issue with Sandra Romero Nunez and her personnel file, because we've given them the disciplinary.
So what Mr. Giannotti said, and this is what interests the court most, I don't mean to cut you off.
No, you're fine.
Is that she appears to still be employed by you.
Your Honor, my understanding is that she is not. I can get.
But have y'all produced a document where it is a termination document?
My understanding in the list of things that I have here, and I can go back and check this, is we produced an exit interview.
Mr. Giannotti, if she produced an exit interview, that would be responsive, and then this is one we could strike off.
Your Honor, they produced an exit interview for the first time she left Walmart to go to jail for better opportunities. They have not produced an exit interview or anything evidencing termination.
Well, and perhaps
after the shooting.
And perhaps we didn't, Your Honor, because she went to jail. And maybe there wasn't an exit interview, but I can probably clear that up pretty easily. And say, hey, is this something we don't have, because she never came back to the store again.
Well, let me tell you, when did the paycheck stop? Because that tells me when somebody's been separated from an organization.
That's something that we can find out.
All right, because that works for me. I mean, if it's an issue of your document doesn't say termination by, but termination, exit interview, any of those things, when did she stop being paid?
That's something I don't have the answer to right now, but that's something we can get, because my understanding for that personnel file is we've produced, everything else that we've produced for these other folks that they don't have issue with.
Okay, because there's some comments for both sides. Sometimes we get so lawyerly in the way, that's why I asked a lot, Mr. Giannotti, let's look at what your request says. Let's look at what you're actually asking them. Sometimes we think too much like lawyers and not enough like people who have to look for what we're asking them to look for. You got me? Because it's not lawyers who are going to go crawling through the paperwork for the most part. It's going to be somebody in HR, or it's going to be who does the initial search. It may get down to where the lawyers are looking through everything, but if you make it simple enough so if Ms. Jelks, if I can't determine when she stopped working, I can determine when they stopped paying.
Yes, Your Honor.
And sometimes it's just in the way you ask.
Okay.
So when I look through these things, I'm going to be looking for that. Does the language make sense to me? Is there a better way to say it? And when I look through these requests, and I go through taking into consideration both your arguments and all of the objections that have been made and all of the representations that have been made about what has or has not been produced, if there's a simpler way to say it, if there's a timeline to it, if there's hey, this needs to be produced by this amount of time, or some document that says we don't have it, because we can just do that. All right, I'm going to produce it, or I'm going to produce something that says we don't have it.
I think the only issue, Your Honor, that I would have with the finality part that Mr. Giannotti brings up, I understand it, but 9/11/26 says you are obligated to continue to produce. This is complex litigation. Something else may come up.
I've done complex before.
Yeah,
this is not new to me.
So, well, what I'm saying is, Your Honor, finality is an absolute.
Like whether the lady still works for you can be final.
Sure, absolutely. I absolutely agree. My hesitation is only that as we continue to go on, we may come across things that we need to supplement.
I'm so clear.
It may develop as the litigation goes on.
I got you. And then once the depositions start, other stuff starts coming out. I get it. It's what is that math term? That exponential discovery in a complex litigation case is exponential. You do one deposition that leads to 6 more. You get one document that leads to a request for 5 more. But what I'm saying is, at some point, we don't need to keep going around the tree about certain things where there can be some finality. This is one of those things that can be final. Personnel issues can be final because you can at some point say, this is the last day they got paid.
I understand that. Absolutely makes sense. And I think with the other issues, like you said, certifications on the finality on some of these issues are just more difficult because of the way that things are going to continue to develop. As he said, we haven't done depositions. So that may, be something that.
Well, let's put it this way. Because this is complex litigation, because I understand the nature of this, because I understand the nature of the positions you both hold with respect to your clients, I'm not in a position right now where I'm talking sanctions and that kind of thing. And I'm gonna question Mr. Giannotti. I'm gonna question you, and I'm gonna be tough on both of you because I take more of a common sense approach to things. If there's a common sense way to work through it and get it done and move to the next thing, that's what I'm looking at.
Yes, Judge.
What I'm saying is, I don't want us to get into a habit in this litigation because we got a long road to go before we finalize all of it. And whether that's through settlement or through a trial. And I love trials. So you will get a trial if that's what you want. But we have a long way to go before that. And so what I don't want is for us to never be able to move forward because we can't get some things put on the board. Okay, so I understand that like I said, discovery is exponential in these kinds of cases. But if we're gonna dither about you have a document that tells your employees how to report incidents, and reports would be something that would be discoverable, then why is it they can't have access to the system that your employees use to report incidents? And let's narrow it. I get that we don't want the whole wide world of incidents, but particularly this store.
Yes, Your Honor. I think if it's store specific, that actually.
Well, I'm not saying I'm gonna limit it to the store because this market thing interests me. And so I might put it a little bit further out, as I've done in other complex litigation cases, if it seems related within location, scope, time, all of those things. But more specifically, if y'all can't even decide that you can find that he can get stuff from this particular store through this system that y'all have designated, then we're already going to have an issue.
I think the issue, Your Honor, is just the amount of material. And if we were able to tailor it in some way, it would be a lot more efficient.
I'm gonna tailor it, but 3 years is not out of the range. From the time this Mr. Jelks walks through the door, from the time the earliest one of these 4 or 5 people walks through the door and begins working to the time when the last person leaves, that's not out of the realm.
And I will just, and I think Mr. Giannotti said this, Your Honor, Mr. Jelk started working there in 23. So he really had only been working there a little less than a year, I believe. So I would ask that the court tailor it to the date that Mr. Jelk started working in the store and then the date of the incident.
Maybe.
Okay.
Because the whole point of this premises liability type litigation is where certain things foreseeable. And so this incident may not have started from the standpoint of Walmart with Mr. Jones. It may have started with a laxity in how these incidents, the interpersonal incidents between employees was treated even before Mr. Jones becomes part of this. But I am going to be reasonable when it comes to the time scope. I'm not going to let them go on some fishing expedition that goes back 10 years because I don't have time for that. I
understand. And I think to your point, I mean, you made this point earlier and it sounds like maybe you haven't decided what you're going to do. Maybe you have decided, but I would just say on the issue of limiting it to the specific store, Your Honor made some good points about irrelevant, things being irrelevant as far as other employees. Mr. Jelk's only working at this store in Fayetteville, specific to this store. The burdensome aspect of going out to the whole state of Georgia as they're requesting. And, we talked a little bit about the difference, or you talked a little bit about the difference in, a products liability case and something of this nature. So we would request that it be specific, to this store in Fayetteville where Mr. Jelks worked.
I think that hear me when I say this. So it's specific to the type of company that we're talking about. And when I've done products liability, I had one case where it was 2 apartment complexes that were like 3 miles apart in the same county. And so even though they had separate entrances, exits, separate management, on the ground management, all of those things, they were still related because of the proximity of the 2 complexes and the number of police reports that involve one or both of them and the overall management of the 2 complexes. So when I say it's got to make sense to me. Well, that made sense for us to hash out between those two properties managed overall by the same people, even though the on the ground managers were different. That's one scope. But in this case, if there's Walmarts in the same region or market, or a lot of people use regional managers. Walmart, that might not be your terminology, but that is open. I'm not going to say I'm going to limit to one store, because I don't feel like that's appropriate in a case where we're talking about foreseeability.
Okay.
So, and to be fair, even reading the briefs, I'm not making a decision until I'm hearing from y'all, because sometimes I like to ask questions about why we're at an impasse on a particular thing.
I understand. And I think I think this is specific to, now I've kind of messed up my list here, but I think that one was specific to request for production number 2, the second set on the all Georgia stores that they were requesting, and the crime. I think with our position is that Mr. Jelks was employed at that one and only store for that specific time period. I understand Your Honor's position and what you were saying about, the area. And so we would request that it be limited to that specific store. I understand that Your Honor is going to, weigh that issue. And I think, Mr. Giannotti talked a little bit about the Apple case. And I think that we already talked about the differences there in the Apple investment case. So I don't know that I have to rehash that, because I agreed with what the court said, and it being unduly burdensome. So that is that issue. I am trying to skip around here, Your Honor.
On RPD 17, where it talks about witness statements.
Yes,
so where based on Mr. Giannotti's representation, Walmart immediately brought in their lawyers to talk to everybody. But between the time of the shooting, which I presume happened in the evening because it was dark outside.
Yes.
And so, did Walmart just close the doors and hold everybody there? Or did they do statements? They collect statements after the police did? So how does Walmart control, how do they say now these are privileged because our attorneys took the statements versus what happened immediately after the shooting? Because generally the police are going to come in and they take statements first. Correct.
And I think that's exactly what happened. And then I think immediately Walmart was anticipating litigation. So they got it, their attorney involved. And what we have asserted is work product, and therefore not discoverable as far as those statements that he has. If there were additional, because they wanted finality on this, and they said, well, there's nothing in the privilege log. Again, on the certifications on finality, I'm a little, hesitant on that because of discovery. But I think with these, we've asked for those. They weren't included in our privilege log. And so my assumption at this point is that we don't have that except for what's related to our attorney that handled that issue. And so that was where the assertion of work product came about. And then I think in relation to this, we produce the personnel file of Mr. Jelks, his exit interview, the master security incident report, Mr. Smith's affidavit. And I just want to address that for a second because Mr. Giannotti brought that up. That was something that was obtained by former counsel. And as soon as we realized that that was something that existed out there, we got it to them. So the delay wasn't, because we were trying to play games. It really was we got this, we need to give this to them. So that was something we just weren't involved in getting prior to getting involved. Okay. Now, I don't know, Your Honor, if you want me to go through.
Well, let's talk about the monthly security tours. So the annual ones were produced, but not the monthly ones. And then they were able to get, I guess, those documents through master security.
Mm-hmm. That's something that I will have to ask about. I don't, if we had it, we would have produced that. I don't see any reason why we wouldn't have. I'm looking for here the RPD it's associated with, but that's something that, if we had it, I imagine that we would produce it. I don't see an issue there.
Okay.
And then as far as their issue with internal documents, so that I think that was one we maybe haven't covered. Number 24. And if you don't have this, let me know, because my list differs from his a little bit, I think, because they dropped some things off. But produce all emails, text messages, et cetera, other documents that mention relate to inappropriate conduct. So we talked a little bit about that and our issues there. We have produced Mr. Jelk's personnel file, disciplinary actions, his exit interview.
Well, let's talk about the stuff that we know happens in an organization, but that you all may assert a privilege to. So
Okay.
let's talk about the fact that there are going to be emails flying. Did you hear what happened in so-and-so office? We need to get so-and-so to address that. Have they talked to everybody? All of the emails that go the corporate, I'm not corporate, my first cousin, corporate. And so she and I talk about things all the time. And so what I know to be true is that if there's a big incident, it's always going to be a paper trail from this person in corporate talking to this person in corporate, suggesting who else needs to get involved. Can we get this from that person? So are you saying those things are privileged, or are you saying those things don't exist?
We have identified the ones that are responsive in our privilege log. So there are emails identified in the privilege log that we indicated, I think, in our 5th supplemental production to them. And we detailed those and the author, the date, all of that. And then we produced the text messages that we were able to obtain from Mr. Jelks and Mr. Carradine in our.
Did they have Walmart issued phones?
No, those were, so that's part of that. I think that also is part of the issue. There are people that have Walmart issued phones where we've been able to produce things. There are people involved that do not and had provided prior counsel screenshots. So it's very piecemeal. And then some of these emails, that we're talking about, that you were asking about, a lot of these store employees, they're not communicating by email, and so I think as far as all of the text messages that we've produced, those are the ones we have, and so those are the ones that we've produced. And so, to the extent that they want something else, they're going to have to, subpoena somebody's phone, or we're going to have to figure that out because we don't have access.
Yeah, because I was wondering about that. I was like, well, how is Walmart responsible for text messages unless they're issuing the phone?
Right. Well, you had the right thought there, because a lot of them, so some of the managers, I think have Walmart issued phones. And so we were able, I think Ryan Reeves was one, for example, we were able to produce some of his text messages from a search that they did. But Jelks and a lot of Mario Carradine and a lot of these other folks, those were screen grabs that prior counsel was able to get. And so we were able to produce literally everything we had on that and all of those individuals. So, as far as number 24, that's number 24. And then 25, that's any interaction, messages, any interaction between Jelks and any other employee, customer, third party. Same response really for that one. And so our position would be that issue is resolved. That issue should be resolved. We've given you all we have on those two requests. And then number 33, all internal documents relating to the incident. including but not limited to emails, reports, messages, or warnings about the incident. Similar in the sense that we immediately involved an attorney, and we explained this to them and said it was all done in anticipation of litigation. We immediately, when something like this happens, Walmart immediately knows that there's going to probably be a lawsuit. And so we've identified those documents that are, specifically protected by work product. So that also should be resolved. I think we talked through Ms. Nunez. Plaintiff's first interrogatory number 17. Now, this was actually only added in their SIR reply. This wasn't addressed, unless I missed something, this wasn't addressed in their original motion to compel.
This is the witness statements?
This is identify each and every Walmart employee who worked at the Walmart store between September 9, 2022 and March 29th, 2024. Give their job title, and then, yes, give their address so we can contact them. These are the people they want to reach out to.
Okay.
And so in our position is that I think what we've done is we gave all the people that were clocked in. We gave about 58 employees. And so they are wanting each and every Walmart employee that worked at that store for, about 2 years or a little less than 2
you said you gave all the people who were clocked in on the date of the incident.
Yes, ma'am. I think there was 58 associates.
But that doesn't address anyone who may have known of prior difficulties, which would have put Walmart on notice of to anticipate an issue. And
so, Your Honor, if we're opening it that wide to any and everyone,
a store full of employees, yeah.
So this goes back to before Mr. Jelk started at the store.
Okay, well, let's assume we want everybody who worked there while Mr. Jelks was at the store. But I think we keep going back to, I don't think you get to limit their ability to establish a pattern or not establish a pattern of behavior or knowledge with respect to whether the premises liability rests with Walmart not doing something that they knew or should have known they needed to guard against. Now, that's a long way of saying you're trying to limit it to the day of the incident. What the crux of the litigation is whether you all knew or should have known that there was a possibility of this happening.
And I think our position is, it kind of goes to that proportionality issue, which I know plaintiffs, we disagree on that. And, OCGA 91126, even though it doesn't use the word proportionality, the limitations that are addressed in that, so unreasonably cumulative, burdensome, if it could be done in a less expensive way, it's in the spirit of proportionality. So even though it's not labeled as such, I think that there's I think our position has always been, we need to limit this in a way that makes sense, right? Because I'm with the court as far as what can we do to, meet our burden, and also, make it where discovery is efficient, it's relevant, it's what everyone's asking for, and it's not a bunch of, hoopla that we're all going to have to go through that has nothing to do with the case or nothing to do with foreseeability or whatever the issue is. And so we are trying to limit these requests, tailor them, really, is really what we've asked for and what we've continuously tried to work with plaintiff to do. And then I don't know, I don't know if I've missed any, but I think those are, I know we want to talk about the numerosity issue, and I can address that.
Well, I mean, that's just whether the court determines that the subparts as indicated, meet the like, are additional versus being part of the whole. And
Correct.
so I can count.
And just for the record, Your Honor, it's number 16, A through E, those subparts, 17, A through E, 20, A through C, 21, A through E, 24, A through F, 33, A through C, and 39. And it is our position, just by simply counting, that it constitutes as more than 58 separate and distinct interrogatories. And we also disagree that plaintiff has met their burden to, have any additional interrogatories. I believe they asked for 20. I don't think that they've shown complexity or undue hardship. And this argument about 100.
You just said this was complex litigation, but then you said
it's plaintiff's burden. It's plaintiff's burden, Your Honor, for leave.
This is my other question. So yes. Mr. Giannotti says, as I look at it, there's more than one plaintiff who's entitled to have their own set of interrogatories and requests for productions of production documents.
They should have done that from the beginning, Your Honor. They
done what?
They didn't separate them. All of their discovery has said plaintiffs, plural, and they've asked their questions on behalf of their clients. So they have never separated them out. And now in the 11th hour, in their reply, only bringing it up and, basically coming up with this argument, they've also pretty much conceded in their briefing. They say, well, we could do this, but, we'll go with the 20 more interrogatories. They never move for leave of court explaining the complexity or the undue hardship. I know. Okay. I said.
Let me ask you this, Ms. Owens. When they have propounded the discovery, and usually when I used to practice, I would say plaintiffs comes now, on behalf of plaintiffs, and then I name the plaintiffs I'm talking about in the first line, and after that is plaintiffs. So who are they naming in the first line?
I'll have to look at that, Your Honor.
Because if you tell me all of them, then your argument makes sense.
Well, I can look at that right now.
And that's a distinction I'll look at with respect to how these cases, how the discovery is counted.
Okay. So it looks like what they've done, and there's a lot here. So they've done it plaintiff intricacies on one. Here's one that just says plaintiffs. Here's one that just says plaintiffs, plural. So they've done it different ways, Your Honor.
Okay. So I'm trying to figure out, I get Mr. Giannotti's argument, but I've done devil's advocate with both of you. I'm trying to figure out whether this was an argument that could have been made from the outset of discovery, as opposed to a Hail Mary argument that's being made now.
I don't think it could be, because of the way that I'm looking at the discovery, and it's been done a multitude of different ways.
Okay. All right. Unless there's something else, y'all have briefed these cases very well, but I do like to hear the arguments, because I get the nuances from that. And since most of the discovery issues are within my discretion, I like the nuances. And so is there anything else I need to know before we adjourn?
I just would like to thank the court and reiterate that Walmart feels that it has complied in good faith, producing a lot of discovery, still, amenable to work with plaintiff in any way we can. And we do feel like we have met our obligations up until this point, responding to the questions as they've been asked.
Okay. All right. So we're going to go through this, and I'm going to get you something on each of the requests that the court has been asked to look at. Some of them is just practical stuff. And so we'll go ahead, and then I'll also try and get you a deadline to get these things done, because I don't want to delay the start of this depositions in this case.
Thank you, Your Honor.
All right, Mr. Giannotti, Mr. Butler, thank you all.
Thank you.
All
Thank you.
right. And thank you to the court reporters. I'm always soliciting. I have a great court reporter, but she's in much in demand. So if you ever want to work for a cool judge, you know, I'm here. I'm not trying to take you away from your practice, but I'm really nice.
Your Honor, on a little bit of just like a housekeeping note, we tried to get a court reporter here today.
It's hard.
He didn't show.
Well, here's the thing. When
She's there. I'm so sorry.
oh, Ms. Noyes is here. So
I'm so sorry, Ms. Noyes. I didn't realize you had joined.
yeah, she's been here since the beginning. So
oh my gosh, thank you.
Here's the thing. Court reporters are like hen's teeth, or more like gold. You can't find them. If you find one, you hold on to them. But there's such demand, so that the court reporter who works with me, she does it as essentially as a favor to me, because she can make more money doing other things. And so when I can get her for trial, it is only because Miss Val is really, really nice to her, and I'm really, really nice. And so she does it as a favor. But I do appreciate working with good court reporters, and I'm always amenable to, especially if Miss Martin is, you know, going on vacation or she's working for another judge, I'm always amenable to working with somebody. All right, thank you all. I enjoyed this. I know I'm hard on you, but I enjoy the back and forth, the thought process that goes into these cases. And I understand that the underlying issues are very, very serious, but I like when you all think through and respond. And so I look forward to working through this case with you.
Thank you, Judge.
All right, everybody take care.
Thank you.
Thank you, Your Honor.
Judge, can we hang back for 1 second?
Ms. Powell, call me.
Okay, yes, ma'am.
All right.
All right, bye.
Mr. Giannotti, do you want a transcript of this or no?
Yes, please.